So typically, you would understand this if a specific law framed it as such, right? So we have provisions in the Pakistan Penal Code, and the Pakistan Penal Code goes back to the 1860s. Then you have a special law that was introduced, which is the Prevention of Electronic Crimes Act, 2016. And the main criticism about this law was that, one, the offences are very vague. Two, that the powers that are given out are too overbroad. Now, vague offences in criminal legislation is a bad idea, because the purpose of a law is for citizens to understand what is illegal, what is not illegal. This doesn't come across very clearly. And the other thing that tends to happen with all our laws, and this is something we've seen with PICA, is that while the language of the law says one thing, the application is quite the opposite. It's even applied to speech that's not restricted under a particular law. So when you ask what is, from free speech to our protected speech, unprotected speech, there are a lot of gray areas. So Article 19 gives you the right to freedom of speech. There are certain subject categories which are subject to restrictions. The restrictions have to be applied as per law, and any restrictions that are included in law cannot be excessively in overbroad manner. There's also a legal requirement when laws are being passed, and that's something that was a critique of PICA that was not kept in mind. Now, what is happening right now is, for instance, we're looking at the language of Section 505, the existing offence that is now being added to the FIA's schedule. And it has particular language, and there's intent, and there's mutiny, and all of those things. But the application that we've seen even of Section 20, for instance, offence against the natural dignity of a natural person, has been applied to institutions. Speech about, and I'm not even saying speech against, critique speech that would otherwise qualify as protected speech, that has been used to charge people with criminal and under this with criminal provisions of PICA and the PPC. So that's the unfortunate part about the law in terms of where it's vague and the way it's put to use. So in what's on paper, in practice, there's always a contradiction. So let me just then read out to you, specifically, right? This is the language of the law. Obviously, when it's reported, etc., some aspects of it are taken, but the language of the law, Section 505, says that whoever makes, publishes, or circulates any statement, rumor, or report. Now, again, there's rumor, that's a vague reference in there, with the intent to cause, incite, any officer, soldier, sailor, etc., to disregard the duty, or those kinds of things. Now, again, law is also developed through jurisprudence, right? How it is settled, and this has happened, let's say, with the Anti-Terrorism Act, and how broadly it was being applied, and what it can and cannot apply to, what is a terrorist offense, what it is not. So that's sort of also the natural development of the law. The problem is that over here, we don't even get to it. The FIRs are registered in a malicious manner. People are dragged through this entire process. There's no saying whether, like I said before, that offenses that don't even fit the crime, those offenses have been made out. So the FIR will be registered, you'll be pulled through a trial. If you get to an acquittal, that's going to be several years later, but the damage has been done. So even if 3 years later they find out, well, the offense wasn't even made out, the fact is the action against you, the coercive action against you has already taken place. And that's the problem with what's going to happen with this as well. It was already being used. It's not as if Section 505 was not being used. And if you look at the FIRs and even the FIRs under PICA, this was being routinely added to FIRs against journalists and activists and political workers. So again, it's not just about language of the law, even when it's sometimes precise. The way that it is applied is in such a roundabout manner and in such a malicious manner that gets ignored. And that's the problem and the reality of how cases are made out in Pakistan. So again, this has existed, it has been applied. What's happening now is, because this falls within the jurisdiction of the police, and because procedures under the Prevention of Electronic Crimes Act, there's some requirement for warrants. Courts have checked the excessive abuse, the way the FIA was implementing certain sections. So the workaround is that amending the schedule of the FIA. So just adding this offence to FIA schedule. So instead of the police, the FIA can act, and FIA can act not under PICA and bound to the procedures under PICA, which were becoming more limiting for them, the way jurisprudence was developing and the way it's written into the law, but was not being followed. So now the workaround this is that the FIA Act gives certain powers to the FIA, and when you put this as a scheduled offence, then you forget about the police and you circumvent all of the court checks, and you're able to just proceed with the investigations and the arrests as you want. So it's really just about making it easier. Of course, it's going to get worse again, right? It's just the entire intent of this seems to be just how do we make it easier so that we don't have to be checked by courts and we don't have to seek permissions that are otherwise required under the law. So this is exactly why, this is why PICA was introduced. This is why this amendment is being made to the schedule. It's to how can you circumvent the court? How can you circumvent a nod from the cabinet? How can you circumvent a permission from the federal or provincial government? So all of these hurdles that prevent the law enforcement agency from directly taking cognizance, arresting, seizing devices, etc., all of that, right? That is always the intent. How do you counter and how do you circumvent any check that the law or procedure puts over you, which is important. And some procedures and protections have to be read into the law. There are some fundamental rights. There are procedures under PICA which specify that a warrant is required for search and seizure. There are certain cognizable offences. For non-cognizable offences, you do have to seek the permission of a magistrate. All of these things were inserted into the law after a lot of pushback and resistance, that it can't be a free-for-all. So from day one, the aim has always been it needs to be a free-for-all for law enforcement agencies, because then it is not limiting in terms of who you can go after and how you can go after them. And this is just one of those measures that is being taken to try and do that. So I just think that while we are hearing now that this is being reconsidered, or there is a statement by the Interior Minister saying that if this impinges or infringes freedom of expression, then it will be reconsidered. But the fact is, why did it go so far that there was cabinet approval? And so the PDM government is now responsible for this. And not very many months ago, they were on the other side of things. And their narrative was very different with respect to free expression, free speech, and this is something we see consistently. When political parties are in opposition, they harp a different tune, and when they are in government, they go back to doing exactly the same things that they criticized. And so the question here is that why was this allowed to happen? And two, an if and but is not good enough. This needs to be withdrawn.